The term Blaine Amendments is a generic word that we use to refer to a number of state provisions that were put in constitutions in the 19th century that basically were about the same thing. These were all provisions, the purpose of which was to say public funds should not go to sectarian institutions. The Blaine Amendments have put a barrier that stands in the way of school choice programs in some states. So even though the Supreme Court has said that tax credits are fine or school vouchers are fine for kids going to religious schools, in some states these Blaine Amendments are standing in the way of choice-based reform. Today, the best argument in favor of the Blaine Amendments is that it makes good sense to keep church and state separate. Supporters of the Blaine Amendment can say governments have scarce funds and it's important to use public funds for public purposes, and a state can decide, if it wants to, that it's going to have an even higher wall of separation than the one that the Constitution requires. The challenge to the Blaine Amendments rests on the claim that discrimination against religion, or discrimination on the basis of religion, is unconstitutional. The US Constitution does forbid states from establishing a religion. But at the same time, the Supreme Court has said that the First Amendment allows states to treat religious and secular institutions in an even-handed way, on an equal basis. And they've gone further. The Supreme Court has interpreted the Constitution to mean that governments may not discriminate against institutions or persons just because they're religious. That rule trumps any effort by states to experiment with stricter rules of their own. So there's at least two ways to sort of fix the Blaine Amendment problem. One way is for the states themselves, either in their legislatures or in their courts, to interpret these amendments or maybe just get rid of them. If a state decides, as Missouri has, to interpret its own law in a strict way to forbid any funding from reaching a religious entity, then the only way to fix this problem is for the US Supreme Court to say that this kind of discrimination violates the First and 14th Amendments.